Good afternoon, LDF supporters and friends. We'd like to invite you to our first ever webcast conversation, this time about the Shelby County versus Holder Supreme Court litigation. I'm Ryan Haygood. I'm the co-director of the Political Participation Group at the Legal Defense Fund, and I'm joined today by our seventh President and Director-Counsel, Sherrilyn Ifill, who joined LDF in January. The staff is very, very excited to have her. We're excited about her vision for the Legal Defense Fund, her strategic plan for moving us forward in this generation and the work that we're going to do together. In our conversation today, which we promised to keep to 45 minutes, we'll talk to you about the Shelby County versus Holder case, and we'll talk to you about what's at stake in this case, LDF's role in the case, and then we'll conclude by fielding questions from you. So we begin with LDF's President and Director-Counsel, Sherrilyn Ifill.
Thank you, Ryan, and thank you all for joining us. We're actually very excited. This is actually our first webcast conversation, and it's an effort for us to engage more intimately with our supporters so that you'll know more about the work that we're engaged in at LDF. I've been on the job for 4 weeks, and I couldn't have come at really a more important time. As many of you know, next week the Supreme Court will be hearing oral argument in what I think is really one of the most important civil rights cases to come before the court in quite some time, and as Ryan has alluded to, Shelby County, Alabama versus Holder. It's a case that challenges the constitutionality of the coverage formula of Section 5 of the Voting Rights Act. And most of you know that the Voting Rights Act has long been called the crown jewel of the civil rights movement. Among the various pieces of civil rights legislation passed during the 1960s, the Voting Rights Act is regarded as one that was really a true game changer for political participation, voting, and power for minorities in the South. And Section 5 of the Voting Rights Act is really seen as the heart of this important piece of legislation. Section 5 is the heart because it did something that was unique in all voting rights legislation. It, for the first time, put the onus, the burden of addressing the issue of discrimination on jurisdictions rather than on the victims of discrimination. And so under Section 5, political jurisdictions that had a history and a demonstrated experience of discriminating against minority voters were required to, before they make any voting change, submit it to a federal authority, usually the Attorney General, for what we call pre-clearance. In other words, they had to get it approved. This meant any change in voting. If they wanted to switch from elections to appointments, if they wanted to add a county council member, if they wanted to move a polling place, if they wanted to change when a special election would be held, they would have to seek permission first from the Justice Department and have it pre-cleared. And this worked a sea change on political participation among minority voters in the South. First of all, it put, as I said, the onus on the jurisdictions rather than on the potential victims of discrimination. This meant that the Voting Rights Act allowed minority groups not to have to marshal their money, their forces, call organizations like LDF and other civil rights organizations and ask could they represent them by bringing a Voting Rights Act litigation suit after the discrimination happened. But instead they could appeal before the discrimination happened by asking the Department of Justice not to pre-clear a change that would have the effect of discriminating against minority voters. And the effect of this has meant several very important things. One, in many cases, the Department of Justice could look at a change that a jurisdiction had planned and determine that it was going to discriminate against minority voters and deny preclearance or object to that change. And the jurisdiction would have to go back to the drawing board, in many cases, back to the community and work out a plan that would not be discriminatory. Secondly, because of the experience of the regime, it really compelled many jurisdictions, those that increasingly sought to comply with Section 5, to engage in dialogue and discussion with members of the minority community that in ways that they hadn't in the past, because they knew that the Section 5 regime required them to ensure that any changes that they were planning did not discriminate against minority voters. And then three, it really reduced the costs of dealing with discrimination, because rather than file the Section 2 suit, one could engage in this administrative action, which essentially really was submitting a plan to the Department of Justice, sometimes submitting additional information to the Department of Justice, and then engaging in efforts to change the plan if need be in ways that would ensure that minority voters were protected. And this change has happened in jurisdictions throughout the South and throughout other parts of the country as well. In fact, 170 jurisdictions are covered by Section 5. Without question, most of the jurisdictions are in the South, and that's because they're the jurisdictions that had the most egregious history of voting discrimination, and that certainly, it seems to me, is uncontroversial. But there are other jurisdictions in Alaska and Arizona. 3 of the boroughs of New York City were covered by Section 5 in 1975 when language minority provisions were added to the Act. And so the Act really does seek to protect minority voters wherever they may be by ensuring that jurisdictions consider the effect of any voting changes that they make on minority voters. So in this way, Section 5 is a critical tool and has been a critical tool in these jurisdictions to ensure that minority voters have a voice. And the question before the court next week, and since the case was heard, since the court decided to hear the case earlier this term, is whether or not Congress's decision to cover those 170 jurisdictions is constitutional. And so I'd like to kind of turn it over to Ryan to talk a little bit about challenges to the Voting Rights Act in the Supreme Court in previous years and the posture of the case as it's come to the Supreme Court this year.
Sure. As Sherrilyn mentioned, the Voting Rights Act and Section 5 in particular is widely recognized as the seminal achievement of the voting rights movement and the civil rights movement more broadly. It has been challenged, however, 4 times in the Supreme Court. Each time the Supreme Court has upheld the Voting Rights Act's constitutionality in an unbroken line of cases. 2 years ago, there was a challenge out of Texas, which is a case that we refer to as the Mudd case, in which a small utility district challenged Section 5's constitutionality. There, the Supreme Court didn't address a constitutional issue, but allowed for the jurisdiction at issue to seek bailout from Section 5's coverage. Shelby County, Alabama is the latest jurisdiction to challenge Section 5's constitutionality. And the issue before the court next week, and the issue that will be on Justice Kennedy's mind and all of justices in particular, is whether Congress, when it recently reauthorized Section 5 in 2006, did so in a constitutional way. And in particular, whether Congress's continual coverage of some jurisdictions, Section 5 covers all or part of 16 jurisdictions, whether Congress's continued coverage of some jurisdictions but not others was constitutional. And the answer is very straightforward. Congress acted at the height of its power when it initially passed the Voting Rights Act, when it initially passed Section 5, because it was seeking to cure an infection in our democracy, an infection that caused discrimination to proliferate in lots of places in our country. And what Congress set out to do originally was tend to those places in our democracy that were the most infected by racial discrimination with a strong antibiotic, which was Section 5. In 2006, Congress looked at the entire nation and considered the places where racial discrimination was concentrated. There's a nationwide provision of the Voting Rights Act, which is Section 2. And there's an important study that was before Congress, which is part of Congress's 15,000-page record, that looked at the places in which Section 2 cases had been successful on behalf of minority voters. What Congress found is that though the covered jurisdictions, the all or part of 16 states in this country that are covered by Section 5, only contain 25% of our country's entire population. But the Section 5 covered jurisdictions accounted for better than 80% of those Section 2 cases that were successful where discriminatory measures were brought down on behalf of minority voters. And so what Congress saw when it looked at the state of voting in America in 2006, when it considered whether to reauthorize Section 5 for another period of time, was that voting discrimination is most concentrated in those places that are now covered by Section 5. Now, this is not to say, as we saw from the past election, that voting discrimination doesn't happen in places outside of the Section 5 covered jurisdictions, in Wisconsin, for example, or Pennsylvania or Ohio. Congress recognized that discrimination happens in other places as well, but what it recognized very keenly is that the way that voting discrimination proliferates or occurs in the covered jurisdictions is in a more intense, a more persistent, and a more adaptive way, such that Section 5 is required in those jurisdictions to beat back consistently robust attempts to make voting difficult on the part of minority voters. And so in 2005 and 2006, Congress, over 10 months, held 21 hearings. They heard from better than 90 witnesses, both for and against Section 5. These witnesses were lawmakers, they were professors, they were litigators, They were grassroots representatives. They were local elected officials, and they heard from 90 witnesses, both for and against Section 5 in determining whether to reauthorize the Voting Rights Act. Congress amassed a record spanning 15,000 pages. And what Congress found is that in the last reauthorization period, Section 5 of the Voting Rights Act served as our democracy's discrimination checkpoint. It blocked better than 1,000 proposed discriminatory changes from taking root, most notably and recently in the city of Calera, Alabama, which is in the county of Shelby, which is the place from which this most recent constitutional challenge originates. In the city of Calera, the city had conducted annexations for better than 15 years, but had not submitted those changes to the DOJ for approval. At some point, the city of Calera does submit its voting changes it does submit its annexations, there were almost 200 of them, along with a redistricting plan. The Department of Justice looked at the annexations and the redistricting plan, which, by the way, reduced the black percentage of the population in the sole black majority district from 70% to 29%. The Department of Justice looked at the proposed changes and found that they were, in fact, discriminatory and told the city of Calera that they could not put those changes into effect. The city of Calera nevertheless held an election using the annexations that were the substance of the redistricting plan, and the result was that the sole African-American city councilman, whose district was previously 70% black, but was reduced to 29% black under this rejected redistricting plan, lost his seat on the city council. The Department of Justice then pursued a Section 5 enforcement action, finding that the annexations and the redistricting plan were unenforceable, undoing the election and requiring the city of Calera to redraw its electoral boundaries in a non-discriminatory way and to then hold another election. Ultimately, the sole African-American, who was one of our clients in the Shelby County case, was restored to his seat on the city council. And this is but one example of many drawn from a very expansive record that Congress considered in 2006 when it ultimately sought to reauthorize Section 5 of the Voting Rights Act for another 25 years.
Obviously, what's alarming about this case is the fact that Congress reauthorized Section 5 in 2006, and it was immediately challenged, as Ryan has suggested. And the case went to the Supreme Court, and in 2008, the Supreme Court upheld the coverage formula that Congress reauthorized in 2006. So now here we are, 4 years later. The court's decision was in 2009, and the court has decided to hear the case again. From our standpoint, nothing really has changed. Congress still had before it the voluminous record that Ryan's referred to. Congress actually did its job. And it's worth noting, and probably a little bit hard to imagine in today's political climate, but there was overwhelming support for the reauthorization of the Voting Rights Act. In the House, the vote was 396 to 33. In the Senate, it was 98 to 0. Not one senator voted against the reauthorization, including the senators from those states covered by Section 5. So we're talking about Congress having engaged in this long process, having developed all of this information, having come to the conclusion that it had the right coverage formula, and having overwhelmingly reauthorized the Voting Rights Act, and the Supreme Court upholding it in 2009, and yet here we are again a mere 4 years later with the challenge that somehow Congress's action in 2006 now is unconstitutional in a way that it wasn't in 2009. We're excited about the argument tomorrow because we're excited to have the opportunity to bring these issues before the court. We filed our brief several weeks ago. The Solicitor General, of course, will be carrying the bulk of the argument. The case is Shelby County, Alabama versus Holder. But LDF's attorney, Debo Adegbile, will be arguing for 10 minutes on behalf of the civil rights groups that intervened in the case. And we're hoping that we can explain to the court and demonstrate to the court why Section 5's formula is appropriate, why this is an area in which Congress has the expertise, and more importantly, in which the founders, the framers of the Civil War amendments, the 13th, 14th, and particularly 15th Amendment, determined that Congress had the enforcement authority to protect the right to vote. We think it's a fairly simple case, but obviously the mere fact that the Supreme Court has decided to take the case means they have questions. And so we're taking this very seriously. I think what we do want to emphasize is that this is really not a case just about the court and Washington, D.C. and Congress. This is really a case about what will happen in hundreds of jurisdictions throughout this country, particularly in the South, where millions of voters reside. The reality is, in the absence of Section 5, we just can't keep up. If we had twice the budget at LDF, if the Justice Department had twice its budget and twice the number of voting rights lawyers, we couldn't keep up with every voting change that jurisdictions seeking to suppress minority voting strength might decide to enact. We can't keep up with a water district in Alamogordo, New Mexico that decides to change the polling places in the black districts. We can't keep up with a town council in Hillsborough, Florida that decides to reduce the number of council members in order to eliminate the black seat. These are things we would not be able to get out ahead of without Section 5. And so the reality is, if the worst case scenario happens, and by no means do we think that that's going to happen, it would mean a sea change in what we've come to really recognize as political participation for minority voters in states throughout this country. So I thought we might pause here and take some questions. We're hoping that some questions did come through. And we thought we'd take a couple and see how far we can get.
So it looks like, and you sort of touched on this so far, Sherrilyn, but it looks like the first question is, what is at stake for voters in this case?
Well, as I said, I think the stakes are actually quite high indeed. We're not alarmists at LDF, and so we're frequently tamping down what are some of the alarmist impulses when these cases go to the Supreme Court. But I have to say, with this one, we feel that, should things go badly, the cause for alarm would be appropriate. Because as I've suggested, we've got to then really think about what will happen out in the field. And as a result of that, we're making preparations now. And we're laying out what are the possible scenarios, good, bad, and worst case scenarios that might come out of the court. And we're making preparations with our vast network of contacts, attorneys, and alumni to think about how LDF would respond to do our job to protect minority voters in these jurisdictions. It's a daunting task. It's going to require a large amount of resources and a large amount of focused attention. But we really feel we have to start that process now. If the Supreme Court issues its decision at the end of the term in June, we don't want to begin then preparing for what the outcome might be. And so we're already engaged in a process of trying to think through how will we respond, whatever the results of the decision may be, to the courts grappling with this question about Section 5.
And I think it's probably, for many of you, considering that the Supreme Court is hearing this case about the heart of the Voting Rights Act at this time, when we've heard so much about voter suppression activities in the past few years, to be thinking about whether this is a genuine conversation to be had. We represented several people in the past 2 years in actions where their states sought to implement discriminatory voting changes. In Texas, we represented a group of black voters who had previously voted in elections in the state of Texas using the only form of ID they had, which was their student ID. The state of Texas passed a law, a photo ID law, which was recognized as the strictest photo ID measure in the country. Under Texas's law, student IDs would no longer be allowed to be used on Election Day, but concealed handgun permits could be used. It was a curious law, to be sure, but what the case was really about, access to the polling place. And for our clients who were students who only had student IDs, this law would have prohibited them from exercising their fundamental right to vote on Election Day. Under Section 5 of the Voting Rights Act, a 3-judge federal court bounced Texas' discriminatory photo ID measure. In the state of South Carolina, we represented, again, black voters who had previously used their student IDs to cast ballots in South Carolina. A 3-judge federal court changed South Carolina's photo ID measure so that ultimately it was a law that was not discriminatory and would allow for a broader range of IDs to be used, including ones that our students could access. In the state of Florida, under Section 5 of the Voting Rights Act, we represented African-American voters who had used the early voting period in 2008. And folks who know about Florida know that African-Americans represented half of those in 2008 who voted during the early voting period. In advance of the 2012 elections, Florida sought to cut in half its early voting period. Under Section 5 of the Voting Rights Act, a 3-judge federal court, on behalf of our clients and many other interveners in the case, found that Florida's proposed cutting in half of its early voting period was discriminatory and required the state to provide the maximum number of early voting hours. These are concrete examples of the way in which Section 5 has recently protected minority voters from proposed discriminatory changes.
Well, what do you say, Ryan, to someone who would say, as you suggested earlier, you know, I watched the run-up to the 2012 elections, and I saw, you know, voter suppression efforts in Pennsylvania and in Ohio and in jurisdictions outside of those covered by Section 5. You know, isn't that evidence that, you know, the challengers are right, that Congress did get the formula wrong, and those jurisdictions should also be covered by Section 5?
Sure. It's a great question, and it's a question that we get a lot, Sherrilyn. Mm-hmm. And the answer is actually pretty straightforward. When Congress considered whether to reauthorize the Voting Rights Act, Section 5, in 2006, it looked at the whole country. And what it found is that voting discrimination in the Section 5 covered jurisdictions is of a different character. It is of the kind that is persistent and adaptive. And that is to say that where one discriminatory change is blocked, it's followed often very swiftly by another. And in many ways, the same kind of discrimination that was blocked earlier. What we saw in places like Pennsylvania and Ohio and Wisconsin is that state law, the state constitution, and even the federal constitution, was useful in beating back discriminatory measures. And this is not at all to minimize the kind of discrimination that we saw proliferate outside of the Section 5 jurisdictions. But when we're looking at the discrimination inside of the covered jurisdictions, those covered by Section 5, Congress recognized that the voting discrimination there is more intense, it's more persistent, and it's more adaptive. And it requires a more intense remedy, a stronger antibiotic.
What do you think is going to be the toughest question that the court may pose next week?
I think it's related to the question you asked, which is, why didn't Congress in 2006 more closely tailor its coverage formula to get the most egregious discriminators in this country? And the answer, I think, is readily available when consulting the expansive record that Congress assembled. The Supreme Court, in a different case, the city of Bernie, which involved a different piece of federal legislation, recognized the reauthorization in the 1982 reauthorization of the Voting Rights Act as the gold standard for congressional records. The U.S. Congress in 2006 strengthened the 1982 record, held more hearings, heard from more witnesses, assembled a more robust record, and so the 2006 record is a more comprehensive record than the 1982 record, which the Supreme Court recognized as the gold standard of congressional records.
And Ryan, you suggested that earlier we'd received a Hotel California question. What was that question?
And I'll kick this one back to you. This question is, isn't Section 5 a bit like Hotel California in the sense that once a covered jurisdiction is checked in, it can never leave?
I love the question. It's actually not true. You know, one of the very important things to remember about Section 5 is that even though it prescribes a certain number of jurisdictions that are covered, Congress never purported to fix those jurisdictions as the only ones that would be covered by Section 5 or as jurisdictions that would be in perpetuity covered by Section 5. And so, in fact, what Congress did was that it did two things. It created two provisions, one called bail-in and one called bail-out, meaning that there's a method by which jurisdictions that have been found to discriminate can be bailed into Section 5. And it also created a bailout formula whereby jurisdictions that have complied with Section 5, have not had Section 5 objections, and have not been found to discriminate in voting can bail out of Section 5. And if I'm not mistaken, every jurisdiction that has sought to bail out has in fact been bailed out of Section 5. Most recently, just this past year, Merced, California bailed out. And even as we speak, all of the jurisdictions in New Hampshire are seeking bailout, and that's expected actually to happen.
That's right. That's right. So we have another question for you, Sherrilyn, which is, given the importance of this case, why have I not heard this case and the upcoming decisions by minority congressmen, the president, those who champion civil rights, et cetera?
Well, that's a fairly distressing question because we sure have been trying to get the word out. As a matter of fact, there's a very big article today on the front page of USA Today talking about this case. And we've actually been surprised and somewhat gratified at the amount of media coverage that seems to have increased over the last few weeks focused on this case. There's going to be a lot more. You're going to hear a lot, trust me, over the next week. Our lawyers are certainly going to be involved in a lot of discussions in the media about this case. I think actually it's really been building the conversation about the Voting Rights Act and Section 5. As you may know, the anniversary of the Selma March is coming up strangely, ironically, next weekend. And so there is really a groundswell of discussion about the Voting Rights Act itself and about voting that really has been building over the last few weeks and that you should expect to see pick up in the coming days. We're doing our best to stay out there. We've been doing a lot of writing. We've been doing a lot of media. We've been talking to our constituencies. I know that Congress has been very focused on this. I was up on the Hill last week talking with various congressmen. I think that Congressman John Lewis is very concerned and is writing something. So it's very, very important, and I think you're going to see an increase in conversations, particularly as we get towards next Wednesday, and then thereafter as we get towards the weekend and the anniversary of the Selma March.
And maybe a related question is, what can we do to get involved?
Well, the first thing you can do is, to get informed, because there's a lot of misinformation about the Voting Rights Act out there, and it's very important that those who, support the Voting Rights Act and support the reauthorization know what they're talking about. Our website, of course, is www.naacpldf.org. And on that website, you can find links to a variety of materials that we've developed that will help you talk about the Voting Rights Act and that set out our position and describe some of the history of the Voting Rights Act. There is a link on our website to a new effort by the Public Broadcasting Service, which just launched, I guess, yesterday. And they are doing an oral history on the Voting Rights Act and asking people to call in and provide 3 minutes of their remembrances of the passage of the Voting Rights Act and its effect on their communities, and they're archiving all of that material. And so you can do that as well. And obviously you can talk to your network of friends, congresspeople, elected officials, and so forth to tell them how important you think this is and that you think they do need to let their voices be heard and to get involved. The reality is, of course, that the case is before the Supreme Court. These are 9 justices who have the authority to decide this case. I do think it's important that they feel that there is a groundswell of support and discussion about this happening in the community between now and decision day. I do think that it matters to Supreme Court justices to know where Americans stand on these issues. So I think as much as you can publicly talk about this and encourage your leaders and the people that you know who are influential to weigh in on this issue and to talk about this issue, I think that's going to be critically important for the posture of the case before the court.
And one additional thing is that the Leadership Conference for Civil Rights and the Jubilee for Selma, Alabama are co-hosting a rally outside of the Supreme Court. They're encouraging people to come and participate in the rally. To Sherrilyn's point, the Supreme Court is aware of where the people are, and it's important to show a show of force. There are several buses leaving from Alabama, from Selma, Alabama, Shelby County, Alabama, and Birmingham. They're anticipating between 8 and 10 buses full of people from Alabama making the travel from Alabama to Washington, D.C. to participate both in the hearing and support of the rally.
And I would say, particularly if you live in one of the covered jurisdictions, which we can provide that information on our website as well so that you'll know. As I've said, there are 3 boroughs in the city of New York. There's the entire state of Texas. There's the entire state of South Carolina and a variety of others. If you live in those covered jurisdictions, I think that it's really important to talk about why you support the Voting Rights Act and to talk about it in your local newspapers, to write op-eds and to talk about it publicly. Because one of the pieces of misinformation out there is that, Section 5 is a kind of holdover. It's a leftover piece of punishment of the South for the crimes of the past. And I think it's really important that people who live in the covered jurisdictions now talk about the fact that they want this protection. Talk about the fact that no senator in the United States Congress voted against the reauthorization of the Voting Rights Act, even the senators from those covered jurisdictions. And that's because even they recognize the effectiveness of Section 5. Even they're not denying the history that existed in those jurisdictions. And they even recognize that Section 5 has become part of the fabric of political participation in their jurisdictions. It's an insurance policy. It makes leaders in those jurisdictions have to confront the minority populations that live within their borders. And so I think if you live in a covered jurisdiction, I think it's more important than ever that you talk about what you see as the value of Section 5, that this is not punishment north against south, but that in fact this has become part of insurance policy in American politics that ensures that minority voters have an equal and effective opportunity to participate in the political process.
And to Sherrilyn's point, our brief, the brief that we filed in the Shelby County case, really focuses very keenly on the way in which Section 5 protected minority voters in very concrete ways from proposed discriminatory changes. These included statewide redistricting plans in places like Texas and Louisiana, to propose polling place changes, to changing the date of an election, the qualifications for running, annexations. These are very concrete ways in which Section 5 protected minority voters from proposed discriminatory changes. And without Section 5, these voters, minority voters, and our clients in particular would be left to fend for themselves in a way that Congress didn't contemplate. You know, one question we often get from people is, when will we know when we no longer need Section 5? And it's a fair question. But when reading our brief and considering what Congress did very seriously in 2006, assembling this expansive record pointing to concrete examples of discrimination in voting, we'll know when we're close to not needing Section 5 when we're not seeing such a robust record of discrimination that's ongoing in covered jurisdictions. LDF, I think, is the rare place where we come to work daily hoping to put ourselves out of business. Though we love the work we do long for a day in which our work is no longer necessary. But we know from what Congress did in 2006, from what we lay out in our brief, that we're just not there yet. And Congress's theme when reauthorizing Section 5 is that there's nothing inconsistent about recognizing concrete progress and yet knowing that there's a need for more. And that's what the Voting Rights Act is really about, recognizing the gains that have been made and yet recognizing that we've not yet arrived at equality yet.
That sounds like actually a perfect way to kind of sum up. And I would say, you know, to those of you who've joined us for this time, if we didn't get to your questions, we're going to keep them and we're going to send out answers to you. And so we'll manage to get to you all at some point. But we also really want to encourage you to just really stay on top of this, to go to our website, to follow our tweets. We're going to be tweeting from, I promise not from the courtroom, but immediately after the argument next Wednesday. And then next Wednesday, we're also, I guess it's Thursday, offering a telephone conference that I'll be on. And I'll be telling you what I saw and heard in the courtroom and a sense of how we think the oral argument went and whether we can make any predictions based on what we heard at the oral argument. And I hope that some of you will join us for that conference call as well. And then we'll continue to put out alerts over the next few weeks and months. And as I said, we're going to be engaged in a process of trying to think through how to manage a post-Shelby world, whatever the outcome. And so we welcome, really, your ideas, your participation. We hope that you'll reach out to us. You can reach us on our website, but you can always reach me at sifill@naacpldf.org. And I do respond always to my emails. And I would look forward to hearing from you. This has been a very exciting time for me. I'm 4 weeks into what I think is the dream job for someone like me who dreamed of being a civil rights lawyer and who started her career 25 years ago at LDF as a voting rights lawyer. It's an exciting time. I'll be honest with you, I wish it weren't quite so exciting in that I wish that the Shelby case were not before the Supreme Court. But it really is a time that tests our mettle and that tests the strength of our work. And we feel ready to meet the challenge. And we're so thankful to all of you who have supported us over the years and who believed in us. And we ask for your continued support as we enter this very important period. Thank you so much for joining us for this first of our webcasts. If it was a little rocky, we're working it out. But we're going to see you again, I hope, soon. Thanks so much, and thank you to Ryan.